Thank you for joining us, and thanks to the organizers, to the Internet Governance Lab, and to everybody else who helped put on this excellent discussion today. What we're going to do is we are now going to have a discussion about the data privacy dilemma, society and institutions. I am going to very briefly introduce my panelists. They are going to then describe a little bit more about what they do and how they got where they are, and start with some relatively brief opening comments. We will have a discussion up here, and then we will leave some time for questions. We do have a hard stop at 12:30, so we will stop then. So to my immediate right is Emma Briant. Her little description in your sheet is not exactly accurate. So she is currently a visiting researcher at the Al-Walid Center for Muslim Christian Understanding at the School of Foreign Service in Georgetown University. And she is an upcoming visiting researcher at the School of Communication at AU. Very exciting. To her right, we have Will Rinehart, who's the Director of Technology and Innovation Policy at American Action Forum. To his immediate right, we have David Brody, who's a Counsel and Senior Fellow for Privacy and Technology at the Lawyers Committee for Civil Rights under the law. And to their right, we have Francella Ochillo. Am I pronouncing that right? Yes? Oh, good. She's the Vice President and Policy and General Counsel at the National Hispanic Media Coalition. So what I think we'll do is we'll just go right down the line, and we'll start with Emma.
Thank you very much. Can everyone hear me okay, or should I? Thank you very much. Okay, great. So a little bit about my background. I'm a British scholar who specializes in propaganda and information warfare research. I've spent about the last 15 years researching that in the areas of counterterrorism, and also looking at migration and how political communication in relation to inequality. So more recently, I was central in exposing the unethical company Cambridge Analytica and SCL, which you might have seen over the last year. So I'm going to respond a little bit to the issue of this kind of dilemma that we're talking about today in relation to that research. I've been working on a new book called Propaganda Machine, The Hidden Story of Cambridge Analytica and the Digital Influence Industry. So one of the theories that I'm kind of using to underpin the way I'm thinking about that book is actually Shoshana Zuboff's new book on surveillance capitalism. And she, of course, talks about how the digital influence industry has evolved in recent times, enabled by and enabling this kind of logic which shapes platforms' business models that now hinge on this perpetual surveillance model. In which users become no longer ends in themselves, they become the means to others' ends. Well, Cambridge Analytica obviously specialized in this kind of form, and this kind of scales globally and has implications for our global politics as well. They were setting out to exploit a model where users became the means to others' ends, and using that kind of, developing a new business model that was about behavioral change. A model that hinges on the perpetual global expansion of data-powered information warfare and dirty tricks. It's also important to put that in context, actually, looking at the way that information warfare evolved over the period since 9/11. Because there were two waves. There was initial wave following 9/11 of companies coming from Madison Avenue who used to be selling rice and then were moving into, selling war. And then you had a wave going the other way when that was seen as not very good model of way to persuade people. And there were specialized companies that really developed new models based on data obtained by mass surveillance and interrogations and so on for psychological warfare in conflict. Entering slowly entering a data-driven sort of political and commercial world, so people going the other way, in an environment, a new sort of economy where data gathering techniques commercially were also expanding. And of course, they were moving into the politics in the global south too. Both of these kinds of like industry companies are of course motivated commercially, and they're all sort of more or less operating an industry standard where there are commercial imperatives to unethical activities and double dealing in international security. But Cambridge Analytica, I would say, would stand out as having had not just a commercial imperative, but also political imperatives that were being operated strategically. Neither of these motivations necessarily mean a company is more ethical or less ethical, but it's actually important that where there is a strategic plan being underlying the mode of expansion. That's particularly serious, particularly when everyday commercial activities are like the normality of online everyday activities are being obscured by the power relations that are being deployed. So transparency is also not going to be sufficient to handle this kind of business model. And journalism alone also can't police the industry. And we've been seeing, really a gap where scholars, I don't think, have been sufficiently addressing the political economy of the influence industry itself. So not just the platforms, but the companies that engage with it, and how they perpetuate a model of expansion around the world. I would stress that we need to not completely detach surveillance for commercial, political, and security purposes in our analysis, because actually companies move their business between these and use these to balance and extend their businesses. So perhaps getting a foot in the door of a country on an entirely conventional marketing campaign, building data resources, researching the people, contacts and experience that then they will use to undertake a nefarious political and governmental campaign. And then, of course, they're making themselves maybe more useful to our governments as well when they have the ability to deploy secretly there. So societal harms can't be assessed by looking at isolated campaigns or even companies or even industries. These are interconnections. And I think that's really important to the kinds of discussing the kinds of dilemmas that we are on this panel. And I'll wrap it up very quickly there. Thank you very much.
Great, thank you.
Do you want me to also kind of just go through my general framing for this as well, or do you want me to just? Okay. Yeah. So yeah, thanks for everyone for being here, and I'd like to also thank the Internet Society for putting this together. The conversation so far have been very, very interesting. So my background is a little different. I actually started at the University of Illinois Chicago. I heard a shout out to Zizi earlier. So as a former student, it was interesting to hear that. But I have been, at least in the last 10 years, working in the policy sphere, thinking more critically about what's going on, talking with legislators and policymakers, working at the FCC and the FTC in various regards. So really my background is a bit different. It's far more policy, it's far more in the weeds. And my personal background is as someone who uses economic analysis, probably is a little bit different than the attorneys, the lawyers, and the communication scholars that are going to be in the rest of the panels. For that, and because of that, perhaps inculcation of economics, I tend to think a lot about three major things, which is, what are the goals, what are the harms that we're talking about, and then finally, what are the trade-offs? And I want to at least kind of highlight those three different elements when we're talking about just generally this conversation. So I think it's helpful to remember that despite us being very involved in these conversations, probably for, again, I've been involved in them for 10 some years, that the policy conversation itself has shifted quite dramatically in the last 2 to 3. That the kinds of things that we're talking about with privacy, the fact that we're even talking about privacy legislation, the fact that both Republicans and Democrats are on board on privacy legislation, and the fact that this is potentially going to happen in this year, is actually quite striking, and is something I haven't seen since my career in this began. That this is actually, I think, a really, really interesting moment where we're talking about privacy that should be at least understood, and indeed the larger context really needs to be understood, because I was there about 5 years ago when the conversations that were happening in Congress were far different. The kinds of ideas that were mentioned within Congress. Of course, we were jostling over questions of privacy, but the emphasis, for example, on perhaps let me say it this way, that there seems to be more bipartisan agreement that something needs to be done, and I think really what we're trying to figure out is what is that exact something. So the problem and the thing that I really have seen as a failure really in the last year is that obviously a lot has come to light about Cambridge Analytica, and as somebody who has a number of friends who work in the advertising sphere and the political advertising sphere, there's always this tension between the political advertisers who potentially would use Cambridge Analytica's tools or not use them because they didn't think they were particularly great, and then the policy conversation and the privacy harms that are evident, or at least should be apparent, with individuals. This is something I don't think that Congress particularly has done a great job of in the last year. And what I mean by that is to say that we've had a lot of bluster when it comes to Cambridge Analytica, but we haven't really gotten down to what are the legal harms that actually did occur. What are the true legal problems that we're facing with Cambridge Analytica? That to me is something that should have been talked about. It has not been present. We've focused instead far more on the kind of, they're clearly the case, the kind of individual harms or the societal harms, the harms to democracy, the harms to kind of dignity, which are very clear, but we haven't really talked about what is the illegality as much as I think we probably should have. That really hasn't been, and it should be, an animating force. And I know some people will disagree with me on this, but the privacy harms question to me is really fundamental to this problem, to this conversation, at least at a policy level, and it really just isn't a thing that we, or at least in Congress, has really tackled with at a fairly high level. Related to that, I think that we need to be conscientious of the clear trade-offs that are going to occur. So, yes, Facebook has allowed a new kind of surveillance, if we want to call it that, to occur. But at the same time, it has allowed individuals to connect. It has given families the ability to share videos and pictures. This is a way that I still keep in touch with my family, which is really over the Midwest right now, in a way that I don't know if we would have been able to do that 20 years ago. Now that's not to say there aren't necessarily problems with those kinds of benefits. There clearly are some things that are embedded within that kind of framework that probably has problems. But I just want to highlight that there are clearly benefits that individuals are getting from these types of platforms. There are informational benefits, though those could be skewed. There are kind of, in the kind of the uses and gratifications literature, the surveillance benefits to just kind of know generally what's going on in your network. And so I think that we need to be a little bit more conscientious that there are benefits to these sites. There are probably harms to these sites as well, but just being much more clear about what we mean with the benefits, the harms, and the trade-offs, I think actually will get us to a better there. The point is that we don't necessarily need to deny that these trade-offs occur, that in fact, perhaps we need to make public policy in the sense that there are certain kind of superior rights that need to be established and that need to be created. I'm not denying that those things probably shouldn't occur, but I don't think that we should deny that these trade-offs are occurring. With that, I will leave to the rest of the panel.
Hi, thank you for having me. My name's David Brody. I'm with the Lawyers Committee for Civil Rights Under Law. The Lawyers Committee is a national nonprofit civil rights organization founded in 1963 at the request of President Kennedy to address racial discrimination, particularly against African Americans and other racial and ethnic minorities. My organization is sort of a broad spectrum civil rights organization. So we do economic justice, voting rights, education opportunity, criminal justice, et cetera. And my work at the Lawyers Committee really focuses on how these different areas of civil rights intersect with technology and privacy. And I think what's really important to keep in mind here is that privacy exists in part to protect us against unfair uses of personal information. And so to that extent, privacy rights are civil rights. And so when we think about protecting our rights online, our privacy rights, these are core civil rights concerns. And they've been part of the civil rights movement since its inception. If you go back to the 1950s case of NAACP versus Alabama, that was about the right to privately associate. And other, the Supreme Court's Fourth Amendment literature is replete with civil rights cases. Current big data practices exploit personal information in a way that has disproportionate harms on marginalized communities, including people of color, women, religious minorities, people from the LGBTQ plus community, people with disabilities, immigrants, and others. These harms are widespread. They include all kinds of discrimination in economic opportunities, whether you're talking about employment discrimination, housing discrimination, discrimination in education opportunities, discrimination in insurance opportunities, discrimination in lending. As has been previously mentioned, it can be used to discriminate and engage in voter suppression online. We have pretty good evidence from 2016 about not just Cambridge Analytica, but the Russian government specifically targeting African Americans online to suppress turnout. It results in retail discrimination, so charging different prices or offering different services online depending on where someone lives or what their behavioral patterns are. And those things are clear proxies for race, gender, and other protected characteristics. It results in digital inequities. So for most of the past couple decades, the privacy conversation has talked about notice and choice. Notice and choice discriminates against communities with lower tech literacy that don't have as much understanding as perhaps the people in this room about the trade-offs that are involved with online data uses. These practices, commercial data practices, have resulted in the amplification of white supremacy. So if you look at the recommendation engines of YouTube and other platforms, they are algorithmically driving engagement with fringe conspiracy theories and white nationalists in order to maximize user engagement at all costs. These harms include, as we are all well familiar, identity theft. But identity theft has an even greater impact on low-income families and communities that are already living on the margin, where any hit to their credit could push them over the edge. And finally, there are personal safety concerns. It's well documented that stalkerware and other and even legitimate sorts of location tracking can be used by domestic abusers to track their victims. Privacy invasions have resulted in LGBTQ plus individuals being involuntarily outed to intolerant family members. So as we think about the commercial data practices ecosystem, there's a lot of digital pollution that these companies are creating in their efforts to maximize user engagement and their own profits from advertising. And so far, the companies have not been forced to internalize the negative externalities of their activities. And so I think a lot of what we're talking about today, when we're talking about federal privacy legislation or other sorts of regulatory activities, is how do we make these companies internalize these negative externalities that are causing massive harms to marginalized communities and all of us in one way or another. This is not a new problem. Over the past several decades, we have engaged with discrimination before. We've passed a lot of consumer protection laws, civil rights laws, anti-discrimination laws that have engaged with these issues in the brick and mortar context, and we have a lot of lessons that we can learn from that and apply to these new businesses. Tech companies are not some sort of magical new unicorn that has never existed before. The form is different, but the substance is the same. So my organization, the Lawyers Committee for Civil Rights, as well as another organization that we partner with, Free Press, has put forth a model bill proposing to prioritize and center civil rights concerns in a comprehensive federal privacy legislative package. And so to that extent, there's certain things that I think would be really helpful as we're thinking about a federal privacy bill, things that would be really helpful to include to address some of these harms that are specifically felt by marginalized communities. So first, it's really important, we need to prohibit discrimination in employment, housing, credit, education, and insurance through the use of personal information on the basis of various protected categories. And when we're making that prohibition, it's not just intentional discrimination that matters, but it's discrimination by disparate impact. And so what does that mean? I think we all sort of know what intentional discrimination is, but the way in which a lot of the machine learning algorithms are operating and the way in which a lot of the real harms are occurring is that the platforms, they're not necessarily trying to discriminate with an asterisk, sometimes they are, but they just write algorithms in a sloppy way that incorporates existing biases, and it produces discriminatory results. Under traditional civil rights frameworks, that too is not permissible, and we have a lot of experience in case law dealing with those sorts of disparate impacts. The next thing is we need to expand public accommodations protections to apply to businesses that operate online. Public accommodations laws are literally the laws that ended segregation. They say that if you are a business that offers services to the general public, you cannot discriminate on the basis of race, gender, religion, etc. It's a historical accident that some of those federal laws do not apply to the internet. They were enacted decades ago before anyone could think about what the internet was. There's a lot of really good state public accommodations laws that are broader than federal law, and some of them, notably California and New York, do apply to the internet. We need to prohibit deceptive voter suppression, the use of personal information for deceptive voter suppression. I think we've talked a bit about Cambridge Analytica and other sorts of uses in 2016. It's only going to get worse next year. And as we're thinking more about the general privacy provisions that we want in a federal bill, there's certain things that should be in there to make sure that we're taking into consideration how to combat discrimination. So there should be routine audits of data processing practices and algorithmic practices for bias and privacy risks. Those audits should, in some sanitized form, be published. There needs to be robust transparency at multiple levels to enable oversight, not just by regulators, but by academic researchers and watchdogs to figure out when disparate impacts are occurring. And then there needs to be a private right of action. And a private right of action is the ability for individuals to bring lawsuits to vindicate their claims. The reason this is a really important civil rights concern is because historically, marginalized communities could not rely upon the government to protect their rights. Every major civil rights law gives individuals the ability to go into court and protect their own rights, and that is vital to protect marginalized communities that often don't have a voice in government. And finally, there's been a lot of talk about preemption in federal law. Personally, I don't think preemption is a good idea, but what I would say is that if some sort of preemption does occur, we need to be extremely careful not to preempt state civil rights laws. The very nature of discrimination is that it involves personal information. So any sort of broad spectrum preemption could sweep in a host of very strong state civil rights laws that prohibit discrimination at the state level. And in many cases, those state laws are stronger than their federal equivalents. So there's a lot of anti-discrimination protections for the LGBTQ plus community, for example. So that's just something we have to keep in mind. Thank you.
Good morning, everybody. Thank you so much for having me here today and Internet Society for putting this together. My name is Francella. I work for the National Hispanic Media Coalition, and my sole purpose is to bring communities that are just on the margins of this conversation into a plain language conversation about what do we need in privacy regulations. I agree with my panelists on a lot of different issues that they brought up today, and I'm going to point out a couple of things that I haven't heard in the conversation that are really essential to crafting any framework. But one thing I want to remind people of is if they look back in 2007 and 2008 when the market fell apart, and back then I just graduated from law school. It was a horrible time to graduate from law school. Had I gone back, I would have told people don't go. And I remember it was before I started working on the Fannie Mae litigation, and we were thinking about, what led to this collapse? How did this get so big? It was monstrous. Nobody understood it. Everybody was speaking a different language, and even if you understood derivatives, you didn't understand why the whole market was collapsing. And I think that there were so many different pockets of third parties that were signing off on bad securities, that were manipulating the market. There were so many different players that were completely unregulated. And what I thought that a lot of people missed in the conversation was nobody was regulating the third parties. And the third parties were the ones that contributed largely to why the 2008 market collapse happened, because they were signing off on a whole bunch of bad securities. And in the end, the entire nation ended up paying for something, and there were still a small percentage of the population that actually ended up becoming exponentially more wealthy. When I think about the internet that we're regulating for 50 years from now and 75 years from now, we're building those building blocks for that internet. So the thing is, we're thinking about that digital society. Like, what are the bricks that we're putting together to build the foundation for that property? And I think that sometimes if we have somewhat of a forward-looking approach, we have to be thinking about who are we crafting this legislation for? Are we crafting it to say that data belongs to the users and we're going to do everything that we need to do to protect it, and that companies or whatever organizations that are using this data have to accommodate that? Or are we saying we're coming up with a regulatory framework that accommodates these companies and is spurring small business and whatever other lobbyist arguments there are? What worries me is that there are a lot of people who are going to end up being taken advantage of. Their data is going to be monetized. They are essentially swept up into this conversation without even being consulted. And the truth is, a lot of the times when I go into offices, if we're bringing like the language from a family in Lost Hills, California, or Albuquerque, New Mexico, they don't know anything about this list. They know nothing about it. This is a fantastic list, although if you haven't had a chance to check it out at the front. But what they do know is they know when somebody takes their credit card information. They do know, why am I getting certain ads targeted towards me when I open up my email account? How come when I sign up for a Just For You Safeway card, they always know what groceries that I buy? How come when I'm walking in a certain place and I open up my phone, it can give me recommendations right there, even though I turn my geolocation off? So these are questions that I feel like people that are outside of DC, they don't care about our lists. What they care about is us coming up with some sort of thoughtful framework that actually addresses the things that they're concerned about. The National Hispanic Media Coalition started as a media advocacy organization, and we focused a lot on how hate speech was actually used to target Latino communities across the nation. So slowly but surely that work, when we were working on platform accountability, morphed into, as we became more of a digital society, work to hold platforms accountable for the way that they use targeted hate speech frameworks online. And what we found was that one of the most dangerous parts of a lot of the tech platforms was their ad networks and how they were essentially like targeting marginalized communities online, some of the things that David brought up, when they were actually using them to target them for ads, whether it was voter suppression, whether it was to exclude them from ads for employment opportunities, or whatever. And I think that one thing that always concerns me when I go into offices is that the very people who are crafting legislation are not consulting with these people and still haven't found a way to bring their voices into the room. And I think that if we want to have something that's thoughtful, we have to really be thinking about who are the people that are going to be most affected. Because the truth of the matter is, most of us in this room, if your American Express gets stolen, or maybe they have a data breach, you can call and cancel it and use another credit card. It's probably not going to stress you out for the day. It's something that can be remedied with a 30-minute phone call. But what happens when you're one of those low-income consumers that has a debit card that's got money that's locked up? And are we really thinking about those people who don't have the same remedies? So turning back to some of the things that I think need to be incorporated in any framework, I think that we need to think carefully about what are we doing to regulate third parties that are using and essentially manipulating and trading that data in that third and fourth and fifth realm on the digital ecosphere. Because the truth is, a lot of those third parties will never come in contact with any of us as consumers. They never have to obtain consent. The consent is usually only obtained at the first contact. So if you go onto a website, maybe you go to Lulu, you're going to buy a skirt, it says, do you consent to my privacy principles? Yes. Maybe if you transfer to PayPal, PayPal says, do you consent? You say yes again. That's probably the last time that any of those platforms will have to gain consent from you. What are we doing to regulate the third and the fourth layer of the people who are trading that information? To the question about who are we crafting this legislation around, one of the things that when Will was talking about how do we actually define what is a data harm, I think we have to start by saying, does data belong to a consumer? That's a question that was answered in GDPR. It's a question that was addressed in California, but we have to be able to address this here in Washington, D.C. Does data ultimately belong to the consumer? And at what point, when you de-identify the data or you feel like you've manipulated it to the extent that it can no longer be identified, does it belong to the party that is manipulating the data? And we have to be careful about where is that line drawn, because it is a blurry line. Then when we start talking about who does this legislation apply to, I think there's an important question that came up in the last panel with the gentleman who brought up the questions about government surveillance. I think we have should have very serious concerns about the way that the government is using third parties to scrape social media and online data to not only track individuals, to turn them over to different agencies, to share their information improperly, coming up with de facto policies that have not been vetted by the public, but they do so through third parties, and those third parties to some extent shield them from having to get any sort of consent. And it's almost like you set up a system of plausible deniability, because then when you get caught and you get stopped, you say, hey, wait a second, we didn't actually do that. But the thing is, they did the request for the proposal to get a third party to build the software. So we have to be thinking about, if the federal government is coming up with the legislation, is the federal government also going to subject itself to those regulations? And I think that the answer is, realistically, based on the congressional temperature, the answer is that they will be exempt. So if the government is going to be exempt from their own regulations, what are we doing to regulate the third parties that are helping them facilitate bad behavior? And finally, I think that we have to be honest about who is actually enforcing and regulating and has the rulemaking authority. Right now, the FTC is woefully inadequate to manage this problem right now. However, they are managing this problem through the COPPA regulations for children's privacy. However, they need more resources, they need more expertise, and the truth is they need rulemaking and enforcement authority, because if they're gonna have any sort of regulatory teeth, we need to think about beefing up that agency. In general, I just want to encourage all of you, when you're thinking about privacy legislation, at its core, if we do not find a way to make this into plain language where people understand what is my data footprint, because there are no longitudinal studies to show 50 years from now, what does it look like when somebody's been tracked for a lifetime? So since those studies don't exist, And we're at the beginning of this era. We need to really think about what kind of internet do you want 50 years from now, and what do you want your participation to look like? Thank you.
Great, so thanks. So I'm going to try to bring the conversation down to some concreteness. We've heard a lot about a variety of real and potential privacy harms. The U.S. is not the first leader in this area. As you all, I'm sure, know, are very well aware that the EU last year, in 2018, implemented its General Data Protection Regulation, which is a very comprehensive attempt to regulate data privacy to some extent and provide a range of data protection mechanisms. California adopted its own privacy bill. And so we have examples to look at. And so as the US federal government is thinking about privacy regulation, what do you think they should take from those other examples, and where specifically is there a need for the US to adopt something a little bit different?
Sure, I'll go. I think if there's going to be a federal bill, it has to be stronger than California.
In what ways?
I think there needs to be a private right of action. I think there needs to be clear and specific things that are off limits. So, when we talk about privacy regulations, and you look at past examples, other laws, a lot of them have centered on this notice and choice framework, where as long as you inform the consumer enough about what you're doing and they agree to it, you're cool. That's fine. That doesn't work in practice. I think we've seen enough examples of it not working. I think, probably even in this room, a lot of people aren't reading every nuance of every privacy policy. I don't. And I think, if you look at other realms of consumer protection and regulation, we always have sort of taken the idea that there are certain baseline protections that everyone is entitled to, and you can't waive them away. We don't allow you to get a discount to have more arsenic in your drinking water. We don't allow you to buy a car without seat belts or airbags because, it's cheaper and easier, and you prefer to live on the edge. And we don't, in many areas, allow businesses to discriminate based on certain types of characteristics. And so I think, the main thing is there needs to be some baseline things where we say this is not allowed. And then above that, you can sort of talk about what can and cannot be consented to and under what sort of frameworks.
It's still on. Thank you. So I wanted to point out as well that the ways in which these laws have responded to the Cambridge Analytica scandal has been deeply disappointing. The ways in which the separation of the different commercial kind of industries is deeply problematic, and the fact that we don't look at the international picture. None of the legislation, as far as I can see, really will address that. And what happens when you've got companies with one hand gathering data from commercial gambling in somewhere perhaps in using a company out of Ukraine or something like this, and then running non-profits to help people with addictions that are citizen services. And then they're also perhaps gathering psychosocial data and biomedical data, and then also connected to another company which is maybe developing apps using state data resources, and then connected to a company that is working in a political campaign. And all of these things cannot really be seen. A lot of the time it's too obscured at the moment, and that's something about the structures of the companies which isn't really being addressed. The data use perhaps a little bit, but a lot of what's going on is actually, it's completely dark. It also isn't really addressing the fact that there are systems that are systematically reinforcing and recreating inequality globally between countries. So if America is sorting out its privacy issues, which I don't know is even happening anyway, but let's say they do, there's still going to be a free-for-all globally, which is destabilizing both for those regions in the global south, which are usually the targets, but also in terms of the effect that has on the West, and also in that this can often be enabling for things like international crimes, and for things like undermining security. So if you have these companies which both do political campaigns as well as security, as well as other types of work, everything is so black boxed that it's really kind of impossible to see what's going on. And actually, our governments are incentivized to look the other way, because as Francella was talking about, these kinds of third parties and these companies are really not being watched properly, and our focus is all on the platforms and not those companies, and that's a really, really important point. So I think that the legislation needs to look more at what we are doing as well in terms of security, because we're, talking about countering foreign governments, but at the same time we haven't fixed the systems that created the problem of SCL Group, which was the parent of Cambridge Analytica that everybody forgets about, which was doing a hell of a lot more than using Facebook data. Thank you.
Can I just add something? I also, because it's like the enormity of this issue, I'm constantly, every single time I'm in an office, it's not that I feel like I want them to fix everything at once, I just want them to fix something. And I think when we think about how HIPAA regulations came into effect, it was based on states moving piece by piece, then coming together for federal legislation, and it's a framework built on hundreds of laws to make sure that when you go in to get an operation, that somebody tells you this is the disclaimer. And all of those things were built to make sure that you got that one notice. And so I think when we're thinking about what is the solution right now, it isn't necessarily to fix everything all at once, but it's for us to be really thoughtful about each piece that we're fixing so that we create a framework that's actually effective.
So, personally, I'd like to see, at this current moment, I actually kind of hope there isn't a federal law, just so that you kind of have a counter to see what actually happens with California, because California is going to go into effect regardless of what happens at the federal level in 2020. There will be impacts that are clearly localized to the California economy, and we'll see what happens specifically to these companies within that specific instance. It's, I guess from a researcher's perspective, at least from my perspective, it's a little, I guess, a little twisted to see this, but I would actually like to see kind of what happens with CCPA before we start doing a federal preemption and a federal bill that, that we've kind of said, at least in the past, as David was saying, that it has to be, stronger than that. But at the same time, some of the things that we've talked about here are pretty expansive. We're talking about solving housing discrimination, insurance discrimination, lending discrimination, voter suppression, retail discrimination, amplification of white supremacy, identity theft, stalking, transparency, private right of action, and then also data ownership. That's a lot to deal with at a federal level. Overall, I do agree very much with Francella that we probably need more enforcement, not more enforcement, we probably need stronger resources at the FTC. I'm very pro-transparency. I think we're going to see what happens very clearly with these kind of third-party data brokers. CCPA is probably going to change that model pretty significantly. It also isn't to say that the FTC hasn't been going after some of these cases. You know, there was an Axiom case not all too long ago. I think it was Axiom on lending discrimination due to an algorithm. So there, in bits and pieces, we're dealing with this, but perhaps not as a comprehensive whole in the kind of package legislation that we'd want to see. Also, just as a general matter, the private right of action just does worry me a little bit. The only reason I do worry about that is because that means that these types of very hard to quantify harms are basically subject to the class action system that we have in the United States. And I'm not saying that's not it's not that I'm against it per se. It's just that I don't know if that's the best way of doing things. I'd much rather see the FTC go after bad actors. I'd much rather see the state AGs go after bad actors. And I do think, or at least I would hope, that the civil rights place that we were in the 1950s and 60s is very different than where we're in right now. We have states like Minnesota, like Chicago, like Illinois. Well, I'm from Chicago, but states like Illinois going after companies that are violating their own state laws, but also using federal laws in order to go after them as well. So there is a lot that's happening. There is a lot of enforcement that's occurring, and it really, to me, seems like we do probably need to step back for a second and really think about what the goals are. I don't really know where that leaves us. I don't know what a federal privacy law really can do that's better. I guess the real purpose of a federal privacy law, as I see it, is if we get into this space, which we could be at the end of this year, where you have a whole bunch of different states. I think there's about 12 or 13 of them that are considering or like looking to engage in their own sort of privacy law. If we have this just disjointed system at the state level, but as I've been seeing it, there's really two models. You have either the CCPA model, or you have something similar to like what Washington State's going for. Those two things, the companies will probably be able to, be compliant. They may not be, absolutely federally, they'll be defensible. They may not be purely compliant. That leaves to me to see what a federal law really would have to do is basically enact CCPA at a national level. And I don't know. I don't know right now if that's necessarily absolutely the best thing to do, considering that the company's effectively already regulated under CCPA anyway.
Well, can you talk a little bit, I'm just for the education of everybody here, what you see as the key differences between what Washington State's doing and what CCPA?
So the Washington State bill looks far more similar to GDPR in the sense that you have, instead of the CCPA is generally written around this set of, basically effectively consumer rights, which even to me seems a little odd considering that California actually had a tort system. Now, again, I'm not a lawyer, so it should be clearly noted that the benefits of those two different systems are something else to debate. But what's happening, at least with the Washington State bill, is it looks a little bit more akin to the GDPR in that you have a data control. I believe it's a data controller. I mean, other people can kind of lay this out, but what it actually does is it establishes, or at least it goes down the route of data controller and data processors and data subjects far more than what the CCPA does, which is right to delete, right to know, et cetera, et cetera. So it looks slightly different, even though basically I don't want to say I would feel that probably enforcement wise they would look very, very similar, but the laws themselves are just slightly different.
And if I could just jump in really quickly, there are lots of things that I would love to explore today, but I won't. But I do want to clarify the FTC is a reactionary agency, which means that they have to have a certain amount of complaints before they actually move forward. So that might mean it's 50 complaints, it might mean 2,000, it might mean 50,000. But until then, they do nothing. They have no enforcement authority. They cannot actually go and sue. So their authority is completely limited. And so that's why I feel like we have to really be thinking carefully, if that's the agency that is tasked with regulating, how much power do they have, and do they actually have the technical expertise that they need?
So the FTC actually does have enforcement authority, and it has sued in a number of different cases. I do want to pick up though on this idea of enforcement, because it's something that's, before we're, to some extent, we're putting the cart before the horse, because I still think we need to define what we're enforcing. But if we're going to talk about enforcement, we've heard a lot of different discussions about a private right of action as one option, the FTC as another. And throughout all of the discussion, there's been an assumption that enforcement is inadequate and that there needs to be more. And so, do we want
to clarify? I should have said rulemaking authority.
Yep.
Rulemaking authority.
Do we want to go down the model of Europe and have data protection agencies, data protection officers? I mean, what is the right model to think about enforcement? There was a lot of discussion about the need for audits and oversight. Who should be doing that?
So I think we have a false dichotomy here. I'm in favor of an all of the above approach to enforcement. There should be FTC enforcement. There should be enforcement by the states, whether that's through state AGs or some sort of state commission, and there should be a private right of action. Yes, the FTC has enforcement authority. They've had Google, Twitter, and Facebook under consent decree for years and have never enforced. In terms of a private right of action, I think that, we have a lot of experience, decades of experience from other consumer protection laws, from other civil rights laws at the state and federal level in terms of how to handle these lawsuits, how to litigate these cases. And so if we're not starting from scratch, we're not reinventing the wheel, we're not, breaking new ground in untrodden territory here by saying that when you have a statutory violation, you should be able to go to court to sue about it under the Civil Rights Act of 1964, the Voting Rights Act, the Fair Housing Act, civil rights statutes dating back to the Civil War, a bunch of others that I'm not remembering at the moment and someone will chastise me for later. All of these statutes are litigated in federal court every day. They're litigated in individual cases, they're litigated in class actions, and the sky has not fallen. Business has thrived and grown with it for the past 50 years. Like, we understand how to handle these cases, and the judiciary is competent to do it. So, I think that for a variety of reasons, a private right of action is not a boogeyman, and it's not something new.
Can I add something? So I agree with him on all that. Sounds great. But one of the things that I've been shouting quite loudly for is actually also that any kind of GDPR type legislation needs to be, including the GDPR, needs to be coupled with proper licensing and regulation of the actual influence industries themselves. So these third and fourth party actors that we were talking about, because if you don't have that, the unethical activities are not going to be discovered, and it's not just about the acquisition and deployment of data. It's also about the frameworks in which that sits, the whole business models and how they're operating more broadly, and applying sort of auditing potentially, or an ability to remove someone's license if they're a bad actor within the industry, and actually producing an industry that is more ethical, and that requires some kind of licensing body or something like that. We have previous models that are non-governmental licensing, in different areas, and it doesn't have to be about state control. So I think that's a really important area that needs to be addressed as well. So that would be my suggestion.
I actually tend to agree with that, and I thought that should have been done a long time ago. A self-regulatory organization that had some sort of not licensing component, but some sort of component that would have allowed for kind of an internal. I don't really know how this works, because that obviously it looks kind of different, at least in the case of these large platforms. I would say that, at least for the never enforcement thing, I mean, from what I've heard, the opening offer for the current case against Facebook was a $40 billion fine, and now they're in the kind of range of $5 to $20 billion range for a fine. I mean, this from what I've heard, and of course the FTC is not, they're very tight-lipped about this, but this looks to be their single biggest enforcement action that they'll probably ever bring against a company. That's pretty massive. I mean, who knows? I guess part of the thing is that there's a lot of worry that the FTC is not able to do the kinds of things that we need them to do and not able to enforce. And to a certain extent, I would like to trust the process before it's broken. If it's broken, at which point we go through these cases and we figure out, hey, the FTC didn't bring a case. They looked at this. They weren't able to do X, Y, and Z. And then we know, okay, these things cannot. We need to give them extra authority. We need to do extra for, give some sort of extra tools to the FTC. I guess I'm at a wait and see moment that I've been doing this for long enough that a couple more years, I guess, doesn't really matter that much to me, except to the point at which you get something federally done. CCPA already exists. There already is a regulation. It's already going to go in enforcement. Many other states are going to do it. I don't necessarily know the huge pressure to get something absolutely done, at least at the federal level right now, considering that there's a lot of different kind of actors and institutions that really are bringing court cases and really are trying to figure out what they can do. And we're only about a year out since at least those most recent Cambridge Analytica stuff happened. So it's still, I don't know, it's still a little early for me.
Can I respond to that just by saying that the fines might be big to us, but they're not punitive particularly. We're seeing, their profits soaring because the industry is actually, if anything, it's been reassuring that they are not really affected by this. So I think we need to, get that in proportion and understand that, the measures that we're taking are not really big enough. And actually, we can't wait because our security has been really put in threat, and our democracies have been made unstable by this already, and we do need to act.
Great. I'd like to open it up to questions from the audience. Ask that you ask a question, not provide a statement. Yep.
I studied Internet of Things, and that's just basically a term for putting lots and lots of cameras and microphones and actuators and software into everything, so that consent is abolished. It's not going to be a meaningful category anymore. All of these things are going to be gathering lots and lots and lots of data about us. The conversation thus far suggested that if that data is used in a discriminatory way or in a way we don't want, that's the harm. Isn't the harm living in a society that watches us all the time?
I think there's a legitimate question about being able to define a harm, and I think that that's part of the what I would hope is outlined in some sort of baseline federal legislation, being able to define what are the parameters of a harm, even if we can't identify a specific harm. We do have some examples, but I agree with you with Internet of Things, with virtual reality. There are all sorts of concepts, emergent technologies that we can't even dream of right now that federal privacy legislation might not be able to address today, but I think that the beauty of it is that we should be able to build into it that this legislation needs to be revisited in 2 years or 3 years or whatever is appropriate amount of time.
And yeah, I agree with you as well. I think, there's lots of types of harms, right? Like there's the discriminatory harms, there's harms from various uses, and then there's also the harms you're talking about from the collection itself. It can be both. And one of the things that I'm particularly concerned about when you're talking about Internet of Things and other things of that nature is, there's just not the ability to consent to a lot of things, even if you wanted to or were perfectly informed, right? So when you think about machine learning processing and what it sort of is at a philosophical fundamental level, this is a computer process designed to find correlations that the human brain and human analytics are not going to see. It is designed to see the unforeseeable. And so if it is unforeseeable, how can you consent to it in the first place?
My comment about a society that watches you, if that's the harm, I think we need to go deeper in the analysis, because it isn't just quote unquote society, it's institutions. It would be, I mean, even at the broadest level, saying that Facebook watches you to me is it's a complicated statement even in itself, because it assumes a certain kind of agency to Facebook, whereas it doesn't, that an individual may be perceived as being watched, and that has its own effect, but it isn't the same as saying that a society writ large is watching you. To me, that we just need to be much more clear when we're talking about these kinds of, not to say that those kinds of harms don't exist, but we just need to be clear about the kind of agency that we're talking about. Is an individual perceiving it, or is it that there's some other outside force that's talking about it? I mean, we could talk also extensively about the algorithm and the algorithmic bias stuff, which I think is also another very complicated question. Having had enough statistics and econometrics in my life to get into this stuff and actually do some of this work, in a consulting manner, it really actually isn't, it's, to make good algorithms at a very, at a deployable level is very, very difficult, even if you know what the hell you're doing, and even if you know how this will impact different and disparate groups. It just is, it's a very difficult question that when I see, for example, there's a new piece of legislation talking about bias in algorithms, I believe it was Warner put it out recently. That to me was just it's a very difficult question to have, because there's a really good, one of my more favorite data scientists, he has a paper that basically lays out the 21 different notions of fairness. When we talk about fairness in algorithms, we're talking about a lot of different things that are going on. The difference between, for example, balancing for a variance class is very different than calibration. And knowing, like as a statistician, like when I hear bias, I think of something that's very different. It just means whatever the mean of the population is. That's something very different. Those kinds of conversations that you have with people who work on these algorithms at every single day, I'm not saying we shouldn't have that conversation. I'm very hesitant to do what I'm currently seeing, at least at the policy level, which is just define away the hardest, most difficult problem, which is what we've done countless time over and over again with agencies. We don't deal with the hard problems. We let the agencies deal with the problems. We've seen this, there's a long history to this. We don't deal with the problems at a congressional level. We let the agencies figure this out, and it's fought between lawyers and economists, and it makes us probably more wealthy, but it probably doesn't actually help consumers all that much.
Working? Hello. Hi, thank you all for this fascinating conversation. I'm Maggie. I'm a PhD student here in AU in the School of Communication. And I'm wondering if any of us agree with what Tatiana said in the first panel about it being impossible to live with dignity within these business model practices. I'm just wondering, with what you understand of the range of possible consequences, what is the real downside of fining a company like Facebook so much that it forces them to transform this business model? I'm just having trouble seeing the downside there, forcing us to imagine ways out of these predatory, invasive data mining business practices. Thank you.
If I could I totally wholeheartedly agree with you. I feel like when people tell me it's really hard to be a surgeon, I'm like, I still want you to go to med school and get certified. So if you don't want to practice, then don't practice. And I think that the truth is that if we don't come up with some way to force companies to do better, they've made it very clear that they have no intention of doing so on their own. The truth is that their obligation is to have a return on their investment for their shareholders, and how they whether it's putting products or services in consumers' hands, that is just part and parcel of the business that they're in. And so the thing is, they're going to do whatever they need to do to get a return on that investment. And I just think that we need to be really careful and thoughtful about creating an environment where they are encouraged to do better and have penalties when they don't.
Yep, a question, please.
Just to respond to that real quick, I think that we need to at least try to investigate what exactly we're meaning about changing practices. I mean, it's one to change kind of information collection and targeting through, for example, ad preferences. We talked about this a little bit earlier. or at least in the previous panel, was talking about kind of these, these ad targeting methods, the kind of tags that are individualized. I know Julie Angwin has done really, really great work on this, but the interesting thing about her work is, of course, the kind of the subtle subtext, which is, she's the one who found out that there's these kind of auto-generated tags about, white supremacy and Nazism that were being allowed on Facebook. From all perspectives, it seems that not a single person actually used those ads. So I guess the question, there's these multiple questions when we're talking about harm, but more importantly, I think we just need to be very, very specific about the kind of business model change that we're talking about. If we're talking about breaking up an ad platform and saying, okay, you have to break up a company through, you split off the users from its ad platform, you have mandated interoperability, that's one type of business change, as compared to, say, a different type of business change that would be, okay, you cannot have any sort of sharing agreements with third parties. You can't have this sort of information is given to third parties. The kind of stuff that happens and the problems that happen with Cambridge Analytica are, I think, of a very, or at least I would hope they're of a very different nature than perhaps the ad targeting question, but maybe they're related in some way. I would just like to see us being very much more clear about the kinds of problems and kinds of business practices. Not to say that they don't occur, they're not problematic. It's just I think we need to be very, very clear about what they look like. And then also the kinds of policies that could actually remediate that. This question of remediability is something that, as a student, I had to deal with a lot, and it's something that a lot of my professors talked a lot about within public policy. This question isn't something that I've seen us as much talk about. Anyway, it's a bit of a rant of my own, but I would like to see us be very, very clear about the kinds of data practices that we're meaning to curb.
So I can give just quickly some very clear specifics from one example, which is Facebook, in 3 ways. So first, about a month or so ago, Facebook settled a lawsuit with the ACLU, Communications Workers of America, and a few other parties about discrimination in housing and employment ads based on gender and age. This goes to the targeting side, right? So as part of this settlement, Facebook is agreeing to sort of sandbox housing, employment, and credit ads separately from the rest of their ad ecosystem and say, we are going to limit the tools that you can use to target these ads. Because previously it was a free-for-all and you could use whatever sort of targeting parameters you want. Facebook explicitly allowed for targeting based on age and gender in violation of various federal laws. And there's lots of ways to target based on proxies for race, whether it's location. So second example, the Department of Housing and Urban Development just filed a case against Facebook for housing discrimination. And that's because Facebook in its ad platform I'm simplifying, there's a lot of violations in the complaint, but one in particular is sort of illustrative. Facebook let you target housing ads based on location, zip code, various other things. And this could be both inclusive and exclusive targeting. So you say, like, I want this ad to go to these people, and it draws a green zone around that location. I don't want this ad to go to this zip code. And they literally drew a red line on a map around the area being excluded from the ad, which is redlining. And then finally, just about a week ago, the Nonprofit Research Institute, Upturn, released new research in connection with, I think they did it with Cornell, and I want to say Northwestern, but I'm not positive, that not just on the targeting side of Facebook, but on the delivery side of the advertisements, there's also discrimination. So targeting is what the advertiser can do with the platform. I want it to go to these people, I don't want it to go to those people, we're going to do some custom audiences, we're going to do some what's called lookalike audiences, various other things. It's a mix of advertiser control and platform control. The delivery side is entirely platform control. It's how is the algorithm going to deliver the ad within the universe of the eligible audience for that ad. And what this new research shows is that even when an advertiser is completely neutral, does all the right things, they're following best practices, I want to be an equal opportunity employer. I'm going to advertise perfectly. The Facebook algorithm still delivers the ad in a discriminatory manner. So even if you want to be a good player, you can't. And that's entirely in the design of the algorithm.
Thank you. Thank you. George Sadowski. My understanding is that in jurisprudence there's a principle of proportionality which says that the punishment ought to be roughly proportional to the harms that have been inflicted by the deed. My concern is that the proportionality of the way we currently think about proportionality is still more based on earlier estimates of harm, and that our metric for assessing the seriousness of harm is essentially pre-digital. That may be changing. It's out of date, and we should reassess that, especially given the harms that are both personal and social. Thank you. Comments?
Can I respond to that? One thing I would say is it's really, really hard to assess the effectiveness or impact of these kinds of campaigns. So that's come up again and again with Cambridge Analytica, people kept coming back to this issue of whether or not they were effective at what their limited aims were. Actually, it's not even just about that. Proportionality can't be measured without measuring some kind of impact. And even the US government, so the Pentagon, I did an interview with Stanley McChrystal's lawyer about information warfare and proportionality a few years back, and they were basically telling me that they assess proportionality in relation to military campaigns, of course. But when it comes to information warfare, because it's something that was considered to be non-lethal, that doesn't mean it might not have third-order effects, of course. Their proportionality wasn't really an issue. It was kind of seen as always proportional. Now, I think assessments like that, even when they're in the kind of military context, are really, really problematic. So we tend to underestimate the impact and the worry of what can be done with data, and especially in an era where we have, medical data, biomedical, psychometric data, Internet of Things, all sorts, and we have no sense of proportionality at all. We like to think we do, but we don't.
I also say, just from a legal context, I think there are precedents in the law for looking at damages outside of a proportionality context as well, right? So if you think about old school black letter law, property rights, if I trespass on your property and just walk across your lawn, I might not do any damage whatsoever, but that's still a cognizable claim. And then in a more modern context, there's plenty of consumer protection statutes, including, within the FTC Act, where you can have enumerated statutory damages. So I think about one of my favorites, we're in Washington, D.C., one of my favorite statutes is the D.C. Consumer Protections Procedures Act, which prohibits a whole lot of unfair trade practices, whether or not someone is actually cognizably harmed by it, right? It's if you engage in this practice, whether or not you actually deceive the person you did it against, that person still has a claim against you, and the statute allows for $1,500 per violation.
So I'm going to take the moderator's privilege to make a final comment and then thank the panelists. But I think I just want to pick up on some of the things that were talked about here. And when we're talking about a really big topic, when we're talking about privacy and when we're talking about privacy legislation, and we're talking about, as Will mentioned, we're talking about a lot of very discrete, to some extent overlapping, but distinct types of harms. We've talked about data brokers. We've talked about discriminatory advertising. We've talked about bullying online. We've talked about broader surveillance harms that just arise from the collection of information. We've talked about deception. And I think as we start thinking concretely, and as we all are in a space where we're urging legislators to think concretely, important, and I think we'll mention this as well, it's important to disaggregate some of these harms and think very specifically about the kinds of policies and the kinds of proposals that we're asking for in response to each and every one of them. And in doing so, I also think it's interesting that here in, I got back from Singapore last night, and it's very interesting that here in the United States, we are turning, so much of the discussion is we want government to do more to try to get us out of the problem. And it assumes a certain amount of trust in the government, which as being part of the privacy, to some extent, being part of a lot of privacy discussions of the last decade is interesting and contrary to where a lot of the privacy discussions have been up until this point in time. So I just point out that kind of interesting dichotomy. And also just one last little point, I'll just say that I think we ought to, as we think through the solutions, we need to think carefully both of the harm that we're trying to identify and think very carefully about both the benefits of any proposed solution and also the costs. And I'll just use one example that's really not about privacy as much, but it's about some of the things that we talked about, some of the responses to the foreign influence campaigns after 2016. After those campaigns, there were a number of hearings where the big companies were brought in before Congress, and they were rightfully questioned about their role and the failure to take certain steps. And one of the inquiries was pushed forward by then Senator Al Franken, where he really pushed the companies, particularly Facebook, about the fact that they had accepted payments for ads in rubles, and that this was really outrageous. And all the companies, I think, rightfully said, well, banning advertisement in rubles isn't really going to help if we're trying to if we're trying to put a stop to foreign advertising, because smart, sophisticated actors can just buy their ads in dollars. But as a result, what it's led to is Facebook adopting a new ad policy pursuant to which only authorized advertisers can purchase any ad about an issue of national importance. And the list of issues of national importance, I encourage you all to go look, it's basically everything. It's the environment, it's education, it's taxes, it's abortion, it's values, it's terrorism, and the list goes on and on. It's literally, I printed it out the other day, it's literally about 20 different things. And what this means is that no foreigner can purchase an ad taking a policy position on any of these issues. And this was done, I think, at the behest of a movement that was really concerned about foreign influence in the elections. But I suggest that if we start moving down a path where, in response to, as a quick fix, we say foreigners can't speak about issues of national importance in our election, we've really, I think, hurt our national conversation, and that has longer-term consequences if you think about, me as an American wanting to have a policy say in what goes on in other countries that have dramatic effects in our country. Again, we're talking about ads. It's not a prohibition on foreign speech altogether, but I think I just point that out as an example of my wariness, at least, of trying to come up with easy fixes to really hard problems. And so I will end there. I invite the panelists if they want to add any brief comments. We're kind of out of time, but if you have a final burning thought, please weigh in, and then
I did want to make sure before we walked out, I don't necessarily think that government is the answer. What I do think is that we have to have a place to start. And what makes me very uncomfortable is sometimes when we put out an actual problem and the response is, well, if we want government action, are you suggesting that we should break up a company? We didn't go there. What we said was that we want you to do better on this specific issue. And I think that we as advocates, digital right advocates, as citizens, have a right to ask questions and have a reasonable expectation that government will participate in the solution.
Thank you. I share that view as well. So please join me in thanking the panelists.
Thanks for a wonderful panel, and we now have 45 minutes for lunch. There's boxed lunch right outside. We're going to get started with panel number 3 at 1:15 sharp right here. See you all then. Thank you.